And I will call this meeting remote hearing of the Judiciary, Finance, and Civil Law Committee to order. It is Tuesday, March 8th. Had to double check. And we are meeting remotely under Rule 10.01. Members, before we get started with the roll, I do want to introduce, we have a new committee legislative assistant, Michaela Brunner. So please be as kind and patient as you can be. Starting a brand new job as a legislative assistant a couple weeks before deadline is not something I would wish upon anyone, but Michaela is more than qualified and is already doing a great job. She's been with us a week, but she's completely on her own now. So welcome, Michaela. We're glad to have you on the team. And with that, we will go to you, Michaela, to do the roll. So please go ahead with the roll.
Chair Becker-Finn.
Present.
Vice Chair Moller.
Present.
Representative Scott.
Here.
Representative Feist.
Present.
Representative Frazier.
Present.
Representative Grossel.
Present.
Representative Herr.
Present.
Representative Hollins.
Present.
Representative Johnson.
Present.
Representative Liebling.
Present.
Representative Long.
Present.
Representative Mortensen.
Present.
Representative Novotny.
Novotny present.
Representative Farr.
Farr present.
Representative Robbins. Representative Robbins. Representative Vang.
Present.
Representative Zhang.
Present.
All right, a quorum is present, and I will note it's the most wonderful time of the year when we're all being asked to be in 3 different places at the same time. So I understand that, and we will be monitoring things. So don't feel like we're going to mark you unexcused if you're presenting in another committee. With that, members, first we're going to move to the minutes. Representative Scott, can I have a motion to approve the minutes from March 3rd?
I would move the minutes of March 3rd, Madam Chair.
All right, thank you. Any discussion to the minutes of March 3rd? All right, seeing none, all those in favor, please say aye.
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 Opposed? All right, the minutes are approved. We've got another busy calendar in front of us today. First on the agenda is, sorry, I went to the wrong sheet of paper, and I know there's different people in and out of committee today. First on the calendar today, we're going to go to is Representative Frederick here. All right, great. Just want to make sure you were here. So I will move House File 1432 be referred to the Human Services, Finance, and Policy Committee. Representative Frederick, I also understand you have an A22 amendment. Would you like me to move that amendment right now?
Yes, please, Madam Chair.
All right, I will move the A22 amendment. Representative Frederick, can you tell us briefly what the A22 amendment does?
The amendment really just kind of points out the data sharing authority that already exists within the statute, but there's some questions regarding what it meant. And so it's kind of like clarifying language just to make it more clear. It's not necessarily doing a lot in that way. It's more of a technical nature and simply clarifying that it's referring to counties back to Chapter 13 when dealing with welfare and investigative data.
All right, any discussion to the A22 amendment? All right, seeing none, all those in favor, please say aye.
Aye.
Aye. Aye.
Opposed? All right, the A22 amendment is adopted. Representative Frederick, please go ahead and tell us about your bill.
Thank you, Madam Chair and committee members. A lot of this is probably going to sound familiar as I presented in committee last year, and it's phase 1 of a stakeholder-led multi-year project to modernize the Vulnerable Adult Protection Statute. One part that you already heard was because because it was part of what you heard last year, and the other part is going to be included with what you just put in the amendment. I'd like to speak to both of these briefly. So what's in the bill? This bill is the first of a two-phase project to modernize this critical protection law. The Vulnerable Adult Act hasn't been updated in 40 years. The statute protects both older adults and peoples with disabilities living at home. The VAA redesign group, consisting of more than 260 stakeholders, worked to get input on how to develop a more person-centered and equity-based adult protection system. The VAA also established a county-based adult protection system for our state. This means that the counties investigate complaints and offer and or provide appropriate services to protect the vulnerable adult or address the underlying problem. This dual role for adult protection workers is greatly in need of a new approach. The reason this bill was before your committee last year is because the current state of the VAA is essentially out of alignment with Chapter 13. Since investigative data in the welfare system is already confidential per Chapter 13, the changes in Section 7 make a simple yet important fix. This fix aligns the classification of investigative data of county maltreatment investigations with the classification of other investigative data in current law. We need to bring it into alignment by clearly labeling it as investigative data so that it's treated as such. This change will provide much needed clarity and will make it much easier for counties to protect the maltreatment investigation process until findings can be made and the investigation is completed. The second change this bill makes is on the amendment that we just put on. As I said, it's just kind of clarifying the data sharing authority that already exists when dealing with this data. And it's a technical fix in nature. This clarification will help counties when supporting a vulnerable adult's health and safety or to prevent or stop maltreatment. Unfortunately, the current law creates some confusion by lead investigative agencies. As mentioned earlier, Minnesota has a county-based adult protection system. This means that there are 87 different counties that have to work with this statute. Some have said to DHS that they don't believe that they have statutory authority to do this sharing. With this change, we hope it helps counties by, one, making it crystal clear that they can and they should coordinate and share data with a case management agency and or the tribes. This will help by explicitly acknowledging the county's ability to do so, as currently allowed under Chapter 13, when supporting a vulnerable adult's health and or safety, or to prevent, stop, or remediate maltreatment. In closing, the updates in this bill and the amendment will help achieve the first steps in modernizing a very outdated and very important statute, will help alleviate confusion for counties regarding data classification and data sharing during the adult protection maltreatment investigations and service offerings, and will provide clarity for counties by making the current data sharing authorities that already exist under Chapter 13 explicitly clear. These stakeholder-led recommendations will ultimately allow counties to better serve vulnerable adults in their communities, and appreciate the community's time to hear the important bill and the amendment today. And we have DHS representatives on hand if there are questions.
All right, thank you for telling us about your bill. I have quite a few people available for questions if members have them, but I don't have anyone on deck to provide testimony. I will remind members that the question before us today is regarding primarily around Section 7 and subdivision 12B, as well as the data sharing language that was explained in the amendment. So we're going to try to, it's a much bigger bill, but we're going to try to stick to those things under the jurisdiction of our committee. And with that, we'll go to member discussion. Representative Scott.
Thank you, Madam Chair, and thank you, Representative Frederick, for answering the questions that I had yesterday. I'm wondering if I did get a response from my questions from Nicole Stockert. Is she present? Is she one of the ones present with the department today?
Ms. Stockert is here today if you have a question for her.
I do. Thank you, Madam Chair. So if you could just, two questions that I had for Representative Frederick were, is at some point, does the investigative data become public? That was one, because in other chapters of law, in other sections of Chapter 13, investigative data, upon completion of the investigation, that data becomes public. And my other question was whether or not audit trails are created with all the sharing of information that goes on in this bill. So if we could just get those two answers on the record, that'd be great, Madam Chair.
Yep. All right. I see I've got Mary McGurran just turned on her video, so I'm going to assume she's the one ready to answer those questions. So if you could introduce yourself and then go ahead and respond.
Good morning, Madam Chair and Representative Scott. Mary McGurran from the Minnesota Department of Human Services. I'm the supervisor for the Adult Protection Unit at the department. And in response to the first question regarding audit trail, correct? So
Yep, and I'll remind members, it's really helpful if we ask one question at a time. I promise to go back to you if you have multiple questions, but yeah, I think let's start with the audit trail question.
Okay, thank you. Okay, public audit trail and public the publication of the data. So the audit trail, because the data sharing is in response to case coordination, service planning, safety planning, and service interventions, and it's being provided by the agency, by the county agency, to someone that they believe will be necessary to support the health, safety, or comfort of the vulnerable adult. The documentation is in case planning or through the agency's own process. It's not in response to a data request. It's being offered for the safety of the person. And in regards to the public nature of the data, so county investigations are about a person, an individual, a private citizen, or a personal care assistant. Investigations by the health department or by DHS licensing, by the Office of the Inspector General, are public because they're about agencies that are licensed by DHS or MDH. So those investigations, when they're about a provider, a licensed provider, are public. When the investigation is about a private person, the investigation is not public, and those are the types of investigations that counties do.
Follow-up, Representative Scott.
Thank you, Madam Chair. So if it never becomes public that maybe there's a bad actor working at one of, that's a personal care attendant or whatever, maybe they're in a nursing home and they've you know, had some issues of maltreatment. So how would the next employer know that there was ever a problem with that person?
So Representative
Ms.
Scott,
McGurran.
sorry, Madam Chair, Representative Scott. So those, when the investigation is about a person in a nursing home or an employee, those are done by the health department. The counties are doing investigations of family members, friends, when the person's neglecting their own needs or potentially a PCA. And in the main part of this bill is the new proposal that when the county is investigating a personal care assistant, that they are able to share the results of that information with the PCA agency. All substantiated maltreatment, regardless of the agency doing the investigation, so this would include counties, substantiated maltreatment is available to background studies to disqualify the individual if they meet those requirements. So it's not public, but it does go to background studies when the maltreatment is substantiated, and it would go to licensing boards if the maltreatment, if there's a need to protect another vulnerable adult, even for the county investigations.
Okay.
Representative Scott.
Thank you, Madam Chair. If you could elaborate a little bit more on the data that's being shared and where it's coming from and where it's going. Is it all agency data? If you could just elaborate on that a little bit. You know, we're not the Health and Human Services Committee here, so we don't completely understand all the nuances of this, but I think it's important that we understand what data is being shared and with whom.
Ms. McGurran.
Madam Chair, Representative Scott, yes, the data is coming from the report of suspected maltreatment, information that the county knows because they may be a provider of services for that person. They may have past reports, information about past reports, and then also Adult Protective Services conducts a strengths and needs assessment with the vulnerable adult and their primary support person to identify what's necessary to support that person to stop the maltreatment, to prevent future maltreatment, to reduce risk of maltreatment. So it's information from their own assessment and from the maltreatment report that would be shared in order to promote the safety of that person.
Representative Scott.
Thank you, Madam Chair. And so I'm assuming then, obviously, if it rises to a criminal level, law enforcement gets involved, then they do an investigation. their own investigation, and then that data would become public eventually when that investigation was over?
Ms. McGurran.
Madam Chair, Representative Scott, that's correct. All reports that come into the Minnesota Adult Abuse Reporting Center, which is the state centralized reporting center operated by the department, all reports that are potentially criminal are referred to law enforcement, and the lead investigative agencies, including counties, have the responsibility, and law enforcement has the responsibility to coordinate for the investigation of any crime.
Thank you, Madam Chair.
All right, thank you. Any additional discussion to the bill? All right, seeing none, Representative Frederick, closing comments.
Thank you, Madam Chair. I think that the bill overall is desperately needed because, like, as I said, it hasn't been updated in the last 40 years. And the updates really do kind of reflect what we've experienced over the last couple of years too, including a definition of self-care. And because we've seen people who have had mental health struggles that have not experienced the severity, or perhaps they've been lucky enough to not have some of those struggles previously. So this bill does a lot of good, and I appreciate the support.
All right, with that, I will renew my motion that House File 1432 as amended be referred to the Human Services Finance and Policy Committee. The clerk will take the roll.
Chair Becker-Finn,
Aye.
Vice Chair Moller,
Aye.
Representative Scott,
Aye.
Representative Feist,
Aye.
Representative Frazier,
Aye.
Representative Grossel,
Aye.
Representative Herr,
Aye.
Representative Hollins,
Aye.
Representative Johnson,
Aye.
Representative Liebling,
Aye.
Representative Long,
Aye.
Representative Mortensen,
Aye.
Representative Novotny,
Aye.
Representative Farr,
Aye.
Representative Robbins,
Aye.
Representative Vang,
Aye.
Representative Zhang.
Aye.
That is 17 ayes.
Some really easy math for your first roll call vote, Michaela. The motion prevails and House File 1432 as amended is on its way to Human Services, Finance, and Policy. Thank you, Representative Frederick, and those who are on deck for questions. Moving right along, the next bill on our agenda is House File 3254, Representative Stephenson bill. I will move House File 3254 be referred to the General Register, and Chair Stephenson, please go ahead and tell us about your bill.
Thank you, Madam Chair, members of the committee. This is a pretty simple bill. It relates to sales agreements between with sales representatives in Minnesota who are facing termination, and how what law applies and how it applies. The legislature passed a bill years ago saying that in these sales agreements that they had to be subject to Minnesota law, that we wouldn't allow choice of law provisions from other states. But we left a little loophole saying that the venue of such disputes could be in other states, which presents both logistical problems for Minnesota sales reps who might have to go out to California or Florida to vindicate their rights in court, which we don't like. But in addition to that, it doesn't really make a lot of sense to say that these agreements have to be governed by Minnesota law, but they can be enforced in other states. We don't really want Florida courts, California courts, New York courts interpreting and applying Minnesota law. So all this bill does is say that these same agreements, in addition to having to apply Minnesota law, they have to be venued in Minnesota if a dispute occurs. It passed out of the Commerce Committee, I believe, last week unanimously, and I'm hoping for a similar level of support here. Madam Chair, I do believe I have one testifier.
Yep, I've got one testifier on the list. Jean Hoff, please introduce yourself and go ahead with your testimony.
Sorry about that. Can you hear me?
Yep, we can hear you.
Okay.
Please go ahead.
Thank you, Chair. My name is Gene Hoff. I work and represent the Manufacturers Agents National Association. in particular Minnesota sales reps. And what Representative Stephenson said was exactly what we're trying to accomplish. This is a longstanding law, was originally passed in 1990 on a bipartisan basis. There's a loophole that we would sure like to close, as Representative Stephenson said, and that is to make sure that if a small Minnesota business, and these are typically 1 to 5 people, if they do their work, if they're not paid, you have a strong law, but we don't want to have to go out 2,000 miles or 1,000 miles away to have it heard. It just diminishes the claim and makes it very hard for a small business to collect what it's owed for the work it does. So that's why we're here.
All right. That was the Mr. Hoff was the only person we had on the list to testify. Members, any discussion to the bill? Seems like maybe one of the most straightforward ones we've had in this committee, Representative Stephenson. All right, not seeing any questions. Quick closing comments, Representative Stephenson.
Please vote yes.
All right, the clerk will take the roll. I will renew my motion that House File 3254 be referred to the General Register. The clerk will take the roll.
Chair Becker-Finn,
Aye.
Vice Chair Moller,
Aye.
Representative Scott,
Aye.
Representative Feist,
Aye.
Representative Frazier,
Aye.
Representative Grossel,
Aye.
Representative Herr,
Aye.
Representative Hollins,
Aye.
Representative Johnson,
Aye.
Representative Liebling,
Aye.
Representative Long,
Aye.
Representative Mortensen,
Aye.
Representative Novotny,
Aye.
Representative Farr,
Aye.
Representative Robbins,
Aye.
Representative Vang,
Aye.
Representative Zhang, Representative Zhang.
Aye.
That is 17 ayes and 0 nays.
The motion prevails. House File 3254. It's on its way to the General Register. Thank you, Representative Stephenson and testifiers.
Thank you.
All right, moving on to the next one. The next one on our agenda today is House File 2399, Representative Noor bill. I will move House File 2399 be referred to the General Register. Chair Noor, please tell us about your bill.
Thank you, Madam Chair, and thank you, members, for allowing me to present this bill. The LBO is charged with objectively evaluating proposed legislation and potential impact on the state's budget. The LBO staff reviews the financial notes for the accuracy and reasonableness and compliance with fiscal note policies prior to submitting to the legislature. This bill, Madam Chair, members, addresses key issue here that we are going to be bringing forward to this committee is about classification of unofficial fiscal notes. It's considered public unless it's requested to be private by the requester. It's a straightforward bill, and I ask for your support. I do have LBO office with us today to testify on this bill.
All right, so I've got Christian Larson. If you can introduce yourself and go ahead with your testimony.
Madam Chair and members, my name is Christian Larson. I'm the interim director of the Legislative Budget Office. As Representative Noor has stated, Section 4 of this bill really just clarifies how we handle classified fiscal notes. It states when a classified fiscal note becomes public, and it also states who does and doesn't have access to the classified fiscal note when it's in a classified status. And the LBO is in support of that language.
All right, we like nice, quick testimony. I have one other person signed up to testify. Britta Rayton, Deputy Commissioner with MMB. Please introduce yourself and go ahead with your testimony.
Thank you, Madam Chair. Again, my name is Britta Rayton. I'm Deputy Commissioner with MMB. We do have a concern with the bill. We believe MMB budget staff should not be prohibited from being involved in the preparation of classified unofficial fiscal notes. MMB has a continuing responsibility to manage the state's financial affairs and partner with and advise state agencies as they assess fiscal implications of legislative proposals. So the goal of our involvement is to really help ensure that the executive branch is providing high quality, accurate information to the legislature that can be relied upon as legislators make decisions about moving forward with legislation. And we're really trying to limit the need for MMB to raise concerns about a fiscal note after it has been approved. And I just want to make sure it's clear that the involvement of budget staff at MMB does not compromise the confidentiality of the note. Budget officers often work in partnership with their agency fiscal staff as they're assessing fiscal impact, so that would not compromise that confidentiality. Thank you, Madam Chair.
All right, thank you for your testimony. I don't have any other testifiers signed up. Members, any questions, discussion? Representative Scott.
Thank you, Madam Chair, and to the bill's author. The amendment that you added in the last committee regarding the election from the majority party, the chair and the vice chair, what was the reasoning for adding that language?
Actually, that's not really before us, as that doesn't have to do with the data piece. So I will allow Chair Noor to answer that quickly, but we're not going to go down that rabbit hole. Chair Noor, if you could answer that really quickly.
Thank you, Madam Chair. I've been a member of the LBO since its inception, so that shows it's fairly new office. So this was to make sure that we remove ambiguity in the process, where when we elect the chair and the vice chair for the this new commission. So that was the main purpose, and to make sure that there's that smooth transition and there's no holding back from that office fulfilling its mission.
Representative Scott.
Thanks, Madam Chair. Thank you for allowing me to ask that question. I don't have any further questions. I'll be voting for the bill today and encouraging my members to do so, but I do have some issues with parts of the bill. So thank you, Madam Chair.
Yep, thank you. Representative Liebling.
Yeah, thank you, Madam Chair. And I just, in the interest of understanding the bill fully, I wonder, Chair Noor, if you could just respond to what Ms. Rayton had to say. It'd be just helpful. Thank you.
Chair Noor.
Thank you, Madam Chair and Chair Liebling. I think the concern is when someone requests that the data be classified as private, and I think it's under Chapter 16 and Chapter 15. I'm trying to pull the 15.08 or 16A.06 subdivision 7, which actually supersedes the authorization that the commissioner shall share, to share that data. So I think that's the concern, and we are working with the department to make sure that we can address that issue in one way or the other. But I think it's in the purview of this committee to look into how data is classified, and we want to make sure that when we as legislators request the data to be classified as private, it stays private rather than being made public. I know we can make it public when we introduce the bill. This is during the before the bill comes before us, because once a bill comes before the committee, then it's a public data rather than a private data. So this is just before the bill is introduced. You're looking to make sure that you've got a fiscal note that addresses the issue. So that's the little bit of the clarity that we want to put forward and say this is not the official fiscal note. It's just the unofficial fiscal note that author is requesting to address an issue, and sometimes we want to make sure that it stays private.
Right, thank you, Chair Noor, and I know too that this is really really in the weeds kind of bill. Nobody's probably nobody's going to be putting out a press release about this one, but it is important, and I appreciate the discussion and appreciate, Chair Noor, your willingness to continue to work with the agencies and make sure that this is a good workable bill as it moves forward. And with that, we've got any other discussion to the bill? All right, I will renew my motion that House File 2399 be referred to the General Register. The clerk will take the roll.
Chair Becker-Finn,
Aye.
Vice Chair Moller,
Aye.
Representative Scott,
Aye.
Representative Feist,
Aye.
Representative Frazier,
Aye.
Representative Grossel,
Aye.
Representative Her,
Aye.
Representative Hollins,
Aye.
Representative Johnson,
Aye.
Representative Liebling,
Aye.
Representative Long,
Aye.
Representative Mortensen,
Aye.
Representative Novotny,
Novotny, aye.
Representative Farr,
Aye.
Representative Robbins,
Aye.
Representative Vang,
Aye.
Representative Zhang.
Aye.
There being 17 ayes and 0 nays, the motion prevails.
The motion prevails. Lots of easy math for you this morning. House File 2399 is on its way to the General Register. Thank you, Chair Noor, and testifiers. Moving right along, I've got House File 3677, a Representative Hanson J. bill. I will move that House File 3677 be referred to the General Register. Representative Hanson, please tell us about your bill.
Thank you, Madam Chair, and thank you, members of the committee. This bill seeks to allow a post-divorce surname change to be handled similarly to how these name changes are handled when they're done in conjunction with the divorce process. Since it's customary here in America for women to change our names upon marriage, women are disproportionately impacted by the current post-divorce name change requirements. Names are important to humans' sense of identity and our sense of self. Changing your name can shift your entire identity. And it's my hope that this bill will help more women revert to their birth names following a divorce, should they choose to do so. Members, we know divorce can be a painful and difficult experience. There's often a desire to hurry up and get it over with, and a sense of urgency to begin separate lives sooner than later. With nearly 1 in 4 marriages ending because of domestic violence, expeditiously finalizing a divorce can also be a matter of safety. Some divorcees choose to change their name at the time of divorce. However, for a variety of reasons, this is not the case for everyone. For those who choose to wait, changing their surname post-divorce requires a court fee and proof of identity from 2 witnesses, which is not required when the name change is done as a part of the divorce proceedings. This bill seeks to provide a more streamlined process for divorcees seeking to change their name after the court has dissolved their marriage. We have plans to address a few pieces of this bill, including on line 2.20, where it says in this state to address out-of-state marriages, like what our testifier Jen will share. We also have some plans to continue discussing line 3.2 with the implementation of a gross misdemeanor penalty. And with that, Madam Chair, I will turn it back over to you and to our testifiers.
All right, thank you for that. I've got Cami Inforzato. If you could introduce yourself and go ahead with your testimony.
Good morning. My name is Cami Inforzato, and I am a women's advocate at the Domestic Abuse Intervention Programs in Duluth, Minnesota. At DAIP, we work to end violence against women, advocate for women, to promote safety from violence, and to use the women's experience to advocate for social change. I'm speaking to you today from my role at DAIP as a domestic abuse survivor and, again, as an advocate myself. I am testifying in support of House File 3677. And what I've learned from working with women is that women become an extension of the abuser's identity and his beliefs. The abuser imposes his will through violence, intimidation, and coercion. And as a result, the survivors give in to his demands to avoid being hurt. And this is just a snapshot of how women begin to lose their identity. Another aspect of abuse is the belief that everything is his, the house, the car, the kids, everything is owned by him. And when she changes her name to his, he interprets it as a brand of ownership, which when she tries to leave or does get to leave, that brand and everything about the violence comes with her. It follows her. This is a trigger. It triggers trauma-inducing memories. It makes it difficult for her to gain her own identity and her own independent way of living and independence of him overall. This has also been my personal experience as well. My ex-husband was an abuser. He killed a nurse who was on her way to work while he was drinking and driving. And I am not that abuser's wife. And I am not that drunken driver's wife. I urge you to vote for this bill. Please help women like me to get their lives back and so that we can define our identity again. Thank you for the opportunity to speak.
Thank you. We don't have any other testifiers on the list, so we'll move on to discussion. Members, any questions or discussion?
Madam Chair.
Oh, Representative Hanson.
I'm sorry to interrupt. I do have Jen Blom on to testify as well. She is a constituent from our area who prompted this, so I'm not sure if she got on your witness or testifier list, but I just wanted to call attention to that. So sorry about that.
Oh, okay. Well, we'll go to her. Sorry, I print out the list the day before, and thank you for the reminder. Ms. Blom, please introduce yourself and go ahead with your testimony.
Hi, my name is Jen Blum, and I prompted this change because my mom needs to change her name back. My mom got divorced from my dad when I was 1 year old, and the divorce was pretty messy since I was involved, and it had to do with custody and things like that. She kept the name so that her and I had the same name. But as we know, divorce can be traumatic, it's stressful. No one gets married anticipating getting divorced. But because during that traumatic time that my mom was trying to deal with a 1 year old and figure out how she could get her life together, she neglected to request to change her name back to her maiden name. And now my father has since been remarried and has passed away, and I'm married and have my husband's name. And she would have to pay close to $1,000 to get her name changed. And based on the fact that men never have to deal with this, I am just really passionate about this being available for all women. It should be easy to change your name back to your maiden name, your given birth name, than trying to prove who you are to the court system. And I greatly appreciate this being brought before everyone. And I thank you for taking the time to hear me today.
I thank you for your testimony. I will say the language in the bill is not specific to men or women. I know that some men do change their names because my husband did. So yeah,
I do appreciate that it applies to both men and women, but I know that women are, like we said, a far higher percentage impacted by this.
Yeah, no, thank you for your testimony. Just wanted to make sure that was clear on the record. Now we'll move on to member discussion. Representative Scott.
Thank you, Madam Chair. And since this is Judiciary Finance, I'm wondering, Representative Hanson, if you know if there is any cost to the courts. I mean, if they were getting this filing fee before, now they're not going to. Is there a significant cost to the court, or do you know? Thank you, Madam Chair.
Representative Hanson.
Thank you, Madam Chair, and thank you, Representative Scott. You know, I was trying to look up the cost of a name change on the court's website last night to answer this question because I was curious about this myself. And unfortunately, the website was down, and so I was not able to pull that information up. But from what I was seeing, this is anywhere, it can cost anywhere from, if somebody's filing it themselves, $30 to $75. If they're hiring a paralegal, obviously there's higher costs associated with that. There's oftentimes some costs associated with getting copies of birth certificates from other states as well. And if you'd like, Representative Scott, I'd be happy to follow up with you once the court's website is up and can give you some more information about a more accurate cost.
Representative Scott.
That would be fine, Madam Chair. I'm assuming that if there's, and I guess I shouldn't assume, but I'm assuming that if the courts say that there's a cost, maybe they would have come forward by now. I don't know. Is this bill moving in the Senate as well, Representative Hanson?
Representative Hanson.
Thank you, Madam Chair, and thank you, Representative Scott. We do have Senate authors. I have not confirmed if they have gotten a hearing date yet, but it has been introduced and there is a companion file there.
Thank you, Madam Chair.
The Senate's a little slow sometimes on hearings compared to us over here in the House. So thank you. Moving on to Representative Feist.
Thank you, Madam Chair. I wanted to speak up strongly in support of this bill, just based on my personal experience. Not to get weird, but I can share a personal story. I was young and married a guy that I met at a concert, and it was a pretty abusive marriage. And I was a paralegal at the time that I got divorced. And so I had help with the process, but it was very complicated and very sad. And I just remember sitting in the courtroom waiting for my divorce decree to get signed by the judge and like weeping. And it was just like an awful, traumatic, painful experience. And if I could have wrapped up my name change in that process, I would have loved to. I lived with my ex-husband's name for many years before I met my current husband. And just seeing that name, you know, reflect on me, it just made me sad every day for a really long time. And so I just really think this is a really smart bill that is very meaningful. And I just wanted to speak up in support of it. Thank you.
Thank you, Representative Feist. Any further discussion to the bill? All right, not seeing any hands raised. Representative Hanson, closing comments.
Well, thank you, Madam Chair and committee members. And again, to our testifiers, these are hard conversations and hard memories for some folks. And so I just appreciate your vulnerability in sharing this and advocating for this change. As you've heard, aligning the post-divorce name change process with the existing divorce name change process has meaningful outcomes. I appreciate your support and thank you for your time today.
All right, with that, I will renew my motion that House File 3677 be referred to the General Register. The clerk will take the roll.
Chair Becker-Finn,
Aye.
Vice Chair Moller,
Aye.
Representative Scott,
Aye.
Representative Feist,
Aye.
Representative Frazier,
Aye.
Representative Grossel,
Aye.
Representative Herb,
Aye.
Representative Hollins,
Aye.
Representative Johnson,
Aye.
Representative Liebling,
Aye.
Representative Long, Representative Long, Representative Mortensen,
Aye.
Representative Novotny,
Novotny, aye.
Representative Farr,
Farr, aye.
Representative Robbins,
Aye.
Representative Vang,
Aye.
Representative Zhang.
Aye.
There being 16 ayes and 0 nays, the motion prevails.
All right, thanks. I was looking if Representative Long had gotten back on, but I know he had a presentation in another committee. So with that, the motion prevails and the bill is on its way to the General Register. Thank you, Representative Hanson and testifiers. Moving on, the next bill on our agenda is House File 3134, Vice Chair Moller bill. Vice Chair Moller, would you like to move your bill?
So moved, Madam Chair.
All right. Vice Chair Moller moves House File 3134. I understand there's a DE amendment. Do you want to move that and explain what you're doing?
Thank you, Madam Chair and members. Yes, I'll move that DE amendment. It reflects some of the negotiations that have taken place surrounding this bill.
All right. Vice Chair Moller moves the DE3 amendment. Any discussion to the amendment? All right. All those in favor, please say aye.
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 Opposed? All right, the DE3 is adopted. Vice Chair Moller, please tell us about your bill as amended.
Thank you, Madam Chair and members. So at one time in our life, many of us have probably had our cars towed. It's not a pleasant experience, but for some Minnesotans who are homeless and destitute and living in their cars, getting their car towed can be more than unpleasant. It can mean depriving them of everything that they own in the world. So in 2008, the legislature recognized the problem and struck a compromise that established a law that allows those who are homeless or otherwise destitute to get their belongings out of their towed cars, even if they don't have the finances to pay the towing and storage fees, if and only if they present documentation of their eligibility from a government agency, a nonprofit organization, or legal aid. There's an article in your packets from 2008, a newspaper article that talked about one of the heart-wrenching stories of somebody who was essentially allowed only to get one shoe out of his car. So legal aid and other pro bono attorneys who take these cases report that items that indigent vehicle owners have been denied include things like medicine, children's homework, children's winter coats in the middle of winter, and purses and wallets that have identification. In one case where a person with a disability was in a car accident and taken to the hospital, the tow lot refused to return the person's wheelchair. In another case, shortly before Christmas, they refused to give back presents the owner had purchased for their children. So while the legislature thought they had fixed this in 2008, there was no remedy provided. And so really a right without a remedy is no right at all. So the bill before you addresses these egregious situations that have risen over the recent past that prompted this bill. It seeks to correct where destitute owners whose cars are towed and after they follow the law and provide the necessary documentation are illegally refused and watch as their belongings are disposed of. So the bill requires a tow lot operator who refuses to return an eligible car owner's belongings to notify the owner of the reason they are refusing compliance. And to ensure there's a remedy to enforce the right, the bill gives the vehicle owner the right to seek an injunction to compel compliance. And if their belongings have been destroyed, seek compensation in the form of statutory damages. The proponents and the industry have engaged in discussions, and the amendment reflects some of those discussions. And I do have a testifier, Madam Chair, Ms. Hannah Anderson, who's here to give a little more details about the bill.
All right, we'll go to Hannah Anderson. Please introduce yourself and go ahead with your testimony.
Thank you, and good morning, Madam Chair and members of the committee. My name is Hannah Anderson. I'm an attorney at Bakery Drinker, and I'm working with Mid-Minnesota Legal Aid on the bill before you. I'm here today to tell you a little bit more about how this bill came to be, what's at stake here, and why it's so important for Minnesotans. For those that may not be familiar, under current Minnesota law, Minnesotans have an unencumbered right to retrieve any and all contents from a towed vehicle without paying the towing charges if they provide documentation from a government or nonprofit agency or legal aid office that the registered owner is homeless, receives relief based on need, or is eligible for legal aid service. Unfortunately, in practice, that unencumbered right has not always been respected by towing companies. In fact, in the last 2 years, our firm alone was referred a couple of pro bono cases where our clients have been prevented from retrieving their belongings despite providing appropriate documentation. Folks at Legal Aid have also confirmed they've received calls about the same issue, which Representative Moller just kind of prefaced for you. And just the other day, we were made aware of a recent complaint filed with the Better Business Bureau raising this exact issue against the same towing company that my firm has dealt with on our 2 cases. In our firm's cases, our clients were homeless and had been living out of their vehicles at the time the vehicles were towed. As you can probably imagine, because they were homeless and living out of their vehicles, everything they owned was inside those cars when they were towed away. In one of my cases, our client's car was towed after he got into an accident. Afterwards, he approached the towing company with documentation in hand and asked to retrieve his belongings from the towed car. He did so well in advance of the 45-day deadline that applied in his case, and the documentation he provided fell squarely within the language of the statute. In fact, he actually gave the towing company several different examples that he was homeless and was eligible for legal aid services. For example, he gave the towing company a signed letter from a local nonprofit agency indicating that he was currently homeless. The towing company, in response, told him they wanted more than the statute requires. They insisted he bring them proof from the state or county showing he received benefits. Our client then reached out to Legal Aid and asked for help. Legal Aid contacted the towing company directly and confirmed that our client was eligible for and in fact was receiving legal aid services based on his indigent status. Again, the towing company refused to release the vehicle's contents and insisted that the client provide documentation that is not required under the statute. Unfortunately, by the time our firm became involved, we learned that the towing company had scrapped the vehicle with all of our clients' belongings inside. This is despite the fact that the towing company had received multiple lawful requests to release the contents and had been reminded that the towing company was interpreting the statute too narrowly. The current law doesn't have any sort of mechanism for seeking release when a towing company flat out refuses to return a vehicle's contents in violation of the statute. The bill in front of you today provides some much needed protection to Minnesotans that find themselves in a situation like this one by providing the right to injunctive relief or limited statutory damages. As you can see from the bill in front of you, the legal remedies that we propose adding are designed to do two things. First, we want to ensure that individuals can pursue temporary injunctive relief if a vehicle has not yet been disposed of by the towing company. This would ensure that the towing company doesn't needlessly destroy everything an individual owns, belongings which are of little to no value to the towing company, merely because the applicable waiting period has expired. Second, we want to ensure that an individual who loses their belongings because a towing company disposed of a vehicle after wrongfully denying access is guaranteed some limited compensation for this violation of their unencumbered rights. Without statutory damages, folks who are often not legally savvy are left to pursue common law causes of action that are made all the more difficult by having to provide evidence quantifying belongings that have been destroyed. We feel that when your entire life and all of your worldly possessions are scrapped in an instant, even after you've done exactly what the statute asks you to do, you should be afforded some sort of relief. We're not talking about anything extravagant here. We're talking about compensating Minnesotans whose unencumbered right to retrieve their own property has been violated. I'm happy to answer any questions you all might have. Thank you very much for your time today.
All right, thank you. We don't have any other testifiers on the list, so we'll move on to member discussion. Representative Scott.
Madam Chair, and Representative Moller, I noticed that the amendment requires that the person seeking their belongings has to show an ID and verify they are who they say they are. And I understand that. What if their ID's in the car? And that's one of the reasons they're there, you know, to try to get that.
Vice Chair Moller.
Thank you, Madam Chair. I don't know if my testifier can answer that. That was part of the negotiations. And I think Ron Elwood is also on the call. So I don't know, Hannah, if you can nod your head, if you can answer that. Okay.
All right, Ms. Anderson.
I can certainly try. Ron may also have some insight on this, but that exact scenario happened in one of our cases where the client, all of her purse and her identification was in the car. And so she was in that, you know, kind of vicious circle where she didn't have the identification she needed to ultimately get into the vehicle and collect her belongings. In that case, she ended up eventually having to get new identification, and that was, you know, something that she had to go through. We have discussed this in negotiations with the Towing Association, and there had been discussion about adding in some sort of provision to make it clear that folks could go in and at least get identification or medicine if that was an issue. We'd gone back and forth with the Towing Association, and there was a little bit of pushback because they wanted to make sure that, you know, there was some sort of reasonable investigation attached there. So, Ron, I would invite, you know, you to let the committee here know, you know, if there's anything else that we should discuss at this point on that question.
All right, we'll go to Ron Elwood. Please introduce yourself and then go ahead with your response.
Thank you, Madam Chair and members. Ron Elwood with Legal Aid. And I don't have much to add to what Ms. Anderson just said. The addition of the identification was something we thought was reasonable that the Towing Association asked for. That makes sense. But I think Representative Scott, that you just put your finger exactly on some of the concerns that we had. Well, what if the ID's in the car? And so the issue at the moment that we're trying to work through is, well, if they want to get the ID, if there's some concern about whether or not the documentation is correct, they don't want the individual to go back to the car and take everything out and, you know, et cetera, et cetera. So we're trying to figure out a way to sort of balance these two legitimate concerns. But I think your point is very well taken. I think frankly, most tow companies would say, okay, get your ID, you know, if that's a requirement for proof. So.
All right, follow up, Representative Scott.
Thank you for that. And, you know, I would hope that they would too, but I would also hope that they'd let a person that needs a wheelchair to get the wheelchair out. So, you know, I wish you well on trying to figure this one out. Because, you know, if you've been living in your car, and your IDs in there, you probably don't have a lot of other ways to, you know, verify who you are. You're not going to have a utility bill, those sorts of things that would provide, that form of ID. So, yeah, I wish you well on that. I hope that you can reach an agreement on that. I think, it's just, I can't stand it when these bad actors do stuff like this. It makes it hard for everybody that's doing the right thing. But I support this bill. It seems like kind of a no-brainer to me. So thank you.
Yeah, thank you, Representative Scott. And I think too, the story about the wheelchair in particular just highlights the cruelty and why apparently, why we need to do this bill. It'd be nice if we didn't have to, if people could just be reasonable, but that's why we're here sometimes, I guess. Moving on to further discussion, Representative Novotny.
Thank you, Chair. And I'll be very brief. I was just wondering if the author would be interested in making other exclusions or some amendments to this before it comes to the floor. My point is that, I can think of many years that I was working part-time and going to school full-time and several jobs that I could have just as easily had everything taken away because I was living out of the car between doing all that. And I think everybody that worked and went to college probably was in that same situation, wouldn't have qualified for any of the legal aid or things that would get you qualified here. And I realized that the previous bill, this was done in previous sessions that, had just the cutout for low income and homeless people. And I don't understand why that is. So would you be interested in working on something to make this overall for people? Because you afford what you can drive, and whether you're lower middle income or homeless, it's still going to have the same effect on you.
Vice Chair Moller.
Thank you, Madam Chair. Thanks for that question, Representative Novotny. I actually asked a similar question when I was talking about authoring this bill, but I do understand that the bill was very carefully crafted in 2008, and I don't know if Mr. Elwood would like to address that issue of expanding it beyond people who are homeless or receiving some sort of public assistance.
Mr. Elwood.
Madam Chair, Representative Novotny, thank you for that question. It took 5 years actually to get the law that we have on the books right now. It started off just like you had indicated, where people should just get their stuff. But after laborious negotiations with the association, their point is that if they don't hold the stuff hostage, they really don't have, in some cases, they don't have any leverage over people paying the towing costs. That's their position. So we just decided, it's like if for our clients, it just didn't seem to make any sense. And of course, all of those cases that Representative Moller talked about were cases that we had back then and have had since. And so, we just try to strike a balance like we always do with the legislature, and that's where we landed. And so that's the history of it. I think maybe in your example, Representative Novotny, perhaps a college student might be eligible for legal aid services with their income. So they might actually squeeze in under the current law. But I hear what you're saying. That's what we tried to do originally, but this is where we landed in the compromise into it in 08.
Thank you, Mr. Elwood. I will remind everyone that we are the legislators, and regardless of what stakeholders may want to see happen, we do have the ability to make good law without their blessing. Sometimes we're not always going to have to make everybody happy. Representative Liebling.
Mm-hmm. Yeah, thank you, Madam Chair. And I am just so thrilled to hear the direction that this is going. Thank you, Representative Moller, for bringing this. I remember the debate when this passed, and Mr. Elwood and I spoke about it. And I was just going to say, this makes me furious when I think about the fact that they're grabbing people's stuff because they towed a car. And it's completely random what is in the car and whose life you're destroying by grabbing their property. That it seems to me like legalized theft, honestly. The whole thing just makes me furious. And I'm delighted to hear that Representative Novotny and Representative Scott are, feeling some of the same thing, because this was very hard to get through even in the form that it's in. It was really hard. I mean, I remember the debate. It was, you know, very, very difficult. And so I would love to go further. And but I really appreciate Representative Moller taking this on. You know, if you hang around long enough, all these issues come around, and I'm just thrilled. And I would be for as strong a version of this bill as you could do, Representative Moller. And what the chair just said, I am completely 100% with that. So thank you.
All right, Representative Johnson.
Chair Becker-Finn, Representative Moller. I understand the concept of this bill, and I agree with a lot of it. Generally, I stay off any bills dealing with towing for the simple reason I've been a victim of predatory towing by a very corrupt towing company that towed my vehicle. I was in a restaurant parking lot, and I was one spot too far over from where the restaurant parking area was, and they towed my car. They said they towed it after a time that they could tow it, but we were out there before the time they could tow. It cost me over $1,000 for the tow bill, plus court costs for the dents they put in my vehicle. It turned out that the operator was actually removed the vehicle, claiming he had a contract with a company in my community. My original issue was not happened down in the metro area, but he actually stole a vehicle from the community I live in and sent the person a $5,000 tow bill to get her car back. He was eventually convicted of the theft of the vehicle. But it's unfortunate that these poor and corrupt, very few bad actors in the towing industry is giving the towing industry a bad name. Most of the towing companies that I've worked with have been good at working with the people to get their property out, especially the essential property they need. These towing companies do not want the vehicles. They don't want to keep them in their yard because they're responsible for any damage while they're in their yard until it's taken. They want to get them out as soon as possible. But there again, most of them are very good to work with. We just have the few that create issues that we bring bills like this forward. I wish there was a better way we could take care of these few bad actors without punishing the rest of them. It seems like every time something comes up, it's one or two incidents or one or two actors cause us to create havoc through the rest of the industry. And I'm disappointed about that. But until we do deal something with just those bad actors, we're going to have to make everybody else that works well with the community, well with the public, and make things harder on them, so we might lose those services. And in severe weather issues where we have a lot of vehicles going in the ditch and stuff, we need those tow companies to deal with it. But with that, right now, I will support this, but like I say, we need to find a better way to deal with the bad actors instead of punishing everybody.
Moving on to Representative Grossel or Vice Chair Moller response.
Yeah, thanks, Madam Chair. No, I appreciate that, Representative Johnson, and I'll just say this does nothing to harm the good towing companies, because if they're giving their stuff back, they're not going to be subject to any liability or anything like that. So this is only really targeted towards those bad actors who, in spite of what the law says, refuse to comply, and it provides that remedy. And the hope is now, with providing this remedy, that they'll actually do what we intended when this law was written in 2008, which was to give people their stuff back.
Sounds like this bill might actually be the solution, Vice Chair Moller. Representative Grossel.
Thank you, Madam Chair and Representative Moller. I know it took 5 years, like Mr. Elwood said, to get this first part of it done. But like every other piece of legislation, and the chair said it right, we are the legislators, and we can make more adjustments to these laws once we have them. You've worked hard on the criminal sex laws, along with other representatives, to make adjustments that are needed. So I would hope that you would work with Representative Novotny or any of the Representative Scott, whoever has some better ideas to help make your bill even better. You want to help people who are indigent and in dire straits. And there's a lot of other people that, without being that in that particular position, that could also use that assistance to help them as well in these situations. So if you would please, keep that in mind. And then I guess I just had one question as far as when these people are going to these towing companies and showing paperwork, do they have law enforcement with them to help facilitate or to be there to say, you know, this is the law and this is what needs to be done? Return their properties.
Vice Chair Moller.
Thank you, Madam Chair. And I will just, I'm happy to work with anybody on making the bill stronger, but what I don't want to have happen is we do that and then it can't pass the other body as well, because we really need to fix this problem. So I'm happy to have some discussions, with Representative Novotny or whoever about potentially doing that. To your question about law enforcement, I'll just point out that the cases legal aid hears about are only the cases legal aid hears about. There've got to be people for whom this is applying that don't even know that this right exists under the law. But I see that Mr. Elwood raised his hand to answer that question about law enforcement.
Mr. Elwood.
Madam Chair and Representative Grossell, typically there is no law enforcement involved in these interactions, but I will point out that the law was crafted so that the statute, now it's 168B 0.07, and it required, or it allows the towing company to have reasonable procedures to protect the safety of the staff and those folks. So it's kind of like, it's a balance. Again, it's always a balance, but typically law enforcement is not involved in these things.
Follow-up Representative Grossell, and then we're going to move to the vote.
Yeah, thank you, Madam Chair. I guess, in my experience, as far as people, when I was working as a deputy sheriff, when they came to retrieve private property or their personal property from vehicles, we would escort them. We'd show up at the yard to make sure that, if they have the paperwork in order, if they have legal aid giving them the proper information to share with the tow company, that they should be able to have somebody there to say, you know what, return their personal property. This is what the court has said. This is what the law is. And law enforcement is there to help people. I helped numerous people to retrieve their property just to make sure that, hey, here's what they're going to take. That's it. But thank you.
All right, thank you, Representative Grossell, and thank you for the discussion, members. Vice Chair Moller, closing comments.
Thank you, Madam Chair, members. This really is a David versus Goliath kind of situation, and I'm really appreciative of the robust discussion we've had today. And I look forward to suggestions to strengthening the bill even further and figuring out if that's a potential solution as well. But I really would appreciate your support on the bill today. Thank you.
All right, Vice Chair Moller renews her motion that 3134 as amended be referred to the General Register. The clerk will take the roll.
Chair Becker-Finn.
Aye.
Vice Chair Moller.
Aye.
Representative Scott.
Aye.
Representative Feist.
Aye.
Representative Frazier.
Aye.
Representative Grossell.
Aye.
Representative Herr.
Aye.
Representative Hollins.
Aye.
Representative Johnson.
Aye.
Representative Liebling.
Aye.
Representative Long.
Aye.
Representative Mortensen.
Aye.
Representative Novotny.
Novotny, aye.
Representative Farr.
Aye.
Representative Robbins.
Aye.
Representative Vang.
Aye.
Representative Zhang.
Aye.
There being 17 ayes and 0 nays, the motion prevails.
The motion prevails. House File 3134 as amended is on its way to the General Register. Really loading up that General Register here in the Judiciary Committee, as always. The last bill on our agenda is House File 3015, a Representative Greenman bill. I will move that House File 3015 be referred to the General Register. Representative Greenman, please tell us about your bill.
Thank you, Madam Chair, and it's nice to be back. This is a simple bill. All it does is add the Attorney General's office to the long list of other state and local agencies that DEED is permitted to share access to employment data that it collects. It limits the data sharing for those specific purposes of enforcing Minnesota's employment and wage theft laws. And it does not change the current designation of that DEED data as private or non-public as designated by Chapter 13. This bill is a legal fix so that one branch of state government is permitted to privately share information with another branch for the purposes of enforcing existing Minnesota law. It provides the AG's office with the information they need as part of their investigation to identify and investigate bad employers who deprive their workers of overtime pay or pay workers less than their agreed upon wages. It's a simple policy change, but here's why it's important. To enforce our laws, the Attorney General's office needs information from employers on the number of employers they employ, the hours they work, how much they're paid, et cetera. This is routine investigation tools to enforce employment law. It's all the information that DEED already routinely gathers from employers as part of administering the unemployment insurance. But currently, DEED is prevented from entering into a data sharing agreement unless we add them to the list of state and local agencies permitted under section 268.19. Without this data sharing information, the AG can obtain it by going directly to the employers with a civil investigatory demand to get the information that the employer is already reporting to DEED. Getting that routine information directly from DEED will alleviate the burden on employers to produce this data through a civil investigatory demand, and will save the Attorney General's office time and resources. I'll let Assistant Attorney General Moller explain a little bit more how it works. But as policymakers, I'd say a few things. First, the current restriction puts an unnecessary burden on employers who are already providing this information and now have to respond to another branch of government with the same information. Second, it makes investigations more expensive because Attorney General's lawyers have to spend time and resources collecting information from the employers that DEED already collects. And third, it doesn't change the current designation of this data as private or non-public. It's designated by Chapter 13. It's important that our AG has the information they need to ensure that Minnesota workers receive the wages they've earned. This bill just gives the Attorney General's office the same access to this data that the Department of Labor, the Department of Human Rights, the local human rights agencies, and the Commerce Fraud Department already have. Not to mention, if you look at the long list in the statute, in the bill, Department of Revenue, Department of Human Services, Department of Health, Department of Corrections, the State Auditor, the Office of Higher Ed, ICE, specific state and local agencies administering public assistance, child support, and criminal law enforcement. By giving the AG the tools about this access to this data, it reduces the burden on employers, it reduces the time and resources for the AG's office, and ensures that state can do its job ensuring that workers receive the wages that they earn. With that, Madam Chair, we have one testifier from the Assistant Attorney General Moller.
All right, Jonathan Moller, please introduce yourself for the record and go ahead with your testimony.
Mr. Chair, members of the committee, thanks for having me. My name is Jonathan Moller, and I am an Assistant Attorney General in the Minnesota Attorney General's office. I've been with the office for 8 years. My work consists of investigating potential violations of Minnesota statutes, chapters 177 and 181, which are Minnesota's employment protections. 177 deals with minimum wage, overtime, and prevailing wage, while 181 is kind of the kitchen sink of employment law statutes. It includes everything from protections on when people need to get paid and how often, to protections for organ donations, to whistleblower protections. So there's a lot of stuff in there. I litigate cases when the office discovers violations.
I've been doing this work since 2019 when the legislature recognized the Attorney General's authority to enforce those chapters of Minnesota law. And prior to that, I spent 5 years representing the Minnesota Department of Labor and Industry, the Minnesota Department of Human Rights, the Minnesota Department of Health, and the Minnesota Department of Corrections, all agencies that also receive this data. Prior to that, I worked in private practice doing employment law. I'm here to testify in support of adding the Minnesota Attorney General's Office to the list of government entities that can receive unemployment insurance data through Minnesota statutes section 268.19 subdivision 1. The office seeks to be added for the limited purpose of supporting its ability to investigate violations of Minnesota's employment protections. Adding the office to that list would be prudent because it would put the office on equal footing as other government entities that enforce Minnesota's employment laws, including DLI, MDHR, other human rights bodies, and the Commerce Fraud Bureau. The limited data that the office would receive is meant to streamline and further the office's active investigations into alleged violations of Minnesota's employment protection laws. Access to this data will increase the efficiency of investigations and allow the office to vet investigations before burdening employers with the requests for information from the office. These investigations make employees who have experienced wage theft whole, and they help employers who follow the law by holding employers who do not accountable. The data the office would receive under this section is subject to numerous safeguards. First, it's classified as private data on individuals or non-public data on individuals. And the data would retain that classification in the hands of the Attorney General's office. As the members of the committee know, private data on individuals is not public and is only accessible to the individual subject of the data, while non-public data is accessible to the public, but is not accessible to the public, but is accessible by the subject of the data if there is one. The data retains that classification in the hands of government entities who receive the data from DEED. By law, the data may not be used as the basis for any lawsuit. This protection combines with section 8.31, which is the statute that the Attorney General's office uses to conduct investigations, which already requires the office has reasonable grounds before it conducts an investigation. As such, DEED data cannot form the reasonable ground required of the office to sue an employer for wage theft. In that way, there are numerous protections already in place that would prevent the data from being misused or forming the basis of an investigatory demand by the office. Reviewing unemployment insurance data is a tried and true investigatory tool used by law enforcement agencies in Minnesota. Agencies like DLI routinely pull this data when vetting potential investigation, and it's also useful data to have to make sure information employers provide is consistent with what is reported to DEED. It saves resources by allowing investigatory bodies like the Attorney General's office to gather information in a non-adversarial way. This information can help the office to determine whether a potential investigation has merit and whether it should proceed to a civil investigative demand, or whether the investigation lacks merit and should be closed before burdening an employer with an information request, which might require them to hire an attorney and dedicate money and resources to gather information that the office could have gotten on its own through DEED at no cost to the employer. This is a common sense bill that will make my job more efficient and less intrusive to employers, and it will also have the goal of helping employers who follow the law by punishing competitors who don't. Thank you for your time.
All right, thank you for your testimony. I do have a couple other people available for questions, but otherwise we don't have anyone else signed up to testify. So we'll move on to discussion. Representative Scott.
Thank you, Madam Chair. Just so many questions on this bill. Representative Greenman, the wage theft bill has been in existence for just a few years. How many cases have been prosecuted or so far, if you give me a rough estimate.
Thank you.
Representative Greenman.
Thank you, Chair, and Representative Scott. I think I would ask the Assistant Attorney General to provide that information.
Mr. Moller.
Yes, Representative Scott. So the wage theft law did a couple things. It created a criminal wage theft penalty, which is not what our office investigates. We are a civil unit, so we have civil enforcement authority similar to DLI. We just have a different toolbox. DLI has an administrative process, while we have the authority to do a pre-suit investigation and then go directly to court and not an administrative process. So the prosecuting of wage theft is something that is done by cities and county attorneys, not by the Attorney General's office.
Representative Scott.
Thank you, Madam Chair. So Representative Greenman, the Attorney General, Assistant Attorney General doesn't know because he's not prosecuting those cases right now. They're turned over to the local authorities. Do you happen to know how many cases have been prosecuted through local authorities?
Representative Greenman.
Thank you, Madam Chair, and thank you, Representative Scott. Because this is the Civil Law Committee, those are the questions I came prepared for. I'm happy to get back to you on that criminal question.
All right, follow-up, Representative Scott.
Thank you, Madam Chair. Well, I'd really appreciate that. It seems that if there was, just a plethora of cases, we would have been hearing about it. To the testifier, just one sort of comment. You mentioned that law enforcement investigates cases regularly and all those things, but they do that based on probable cause. This seems to me like a fishing expedition. And to the testifier, does the Attorney General's office, will they have to hire more people to go through all this data? That's a lot of data.
We'll just remind folks that the question before us is whether the data should be shared with the Attorney General's office for the purpose of conducting an investigation pursuant to section 177.45 or 181.1721. Mr. Moller, to the question.
Yes, like I said, we do civil investigations. So similar to DLI, what happens when we find violations is that we would issue a demand for back wages, and then the law allows employers to or employees to have other potential damages like liquidated damages if they haven't received wages. Like I said in my testimony, there are safeguards. We must have reasonable grounds to investigate. So it's a different legal standard than probable cause, but we are not able to just go on fishing expeditions. We need to have a basis for our investigations.
Follow-up, Representative Scott, and then there's a lot of other member questions. I will note that the fiscal note had zero cost. Representative Scott.
Thank you, Madam Chair. Well, the question that I did just ask, and I know you said keep it to the purview of this committee, and that question definitely did address the purview of this committee. I just want to close by saying this is a bill that I feel is what I said before, a fishing expedition. I will not be supporting this bill. We don't need to turn this over to the Attorney General's office to use this to beat the brow of businesses. The Attorney General's office should be worried about, finding fraud in other areas of existing government. And so, Madam Chair, thank you for allowing me the questions.
Yep, Representative Grossell.
Thank you, Madam Chair. And I guess, maybe I missed it, but doesn't the AG's office already have this data if they're doing an investigation?
I'm going to go to Mr. Moller.
Representative, we do not currently have access to this data. We can get access to the data by requesting it from employers. But the utility of getting it beforehand is that we don't have to burden an employer with a civil investigative demand. And this data can sometimes help us vet cases and potentially
understand that there's no violation before burdening an employer with a request. For example, if we received a complaint that an employee isn't getting paid minimum wage, the data that we get from DEED can help us to determine whether that's true or not, because employers report quarterly to DEED how many hours employees work and how much they're being paid. So instead of sending a demand to the employer for information, we could get that from DEED and just tell the complainant that, yeah, we don't have, we're not going to be pursuing the investigation. We're not going to be bothering the employer. Another example is the equal pay for equal work law, which is also in 181. So if we get a complaint from an individual saying that she's not paid commensurate with the male counterparts at her work, the DEED data would allow us to evaluate that claim, whether that claim has any merit at all, before requesting information from an employer that would go to one of the exceptions to the rule, like that it's a merit-based pay system, et cetera, or seniority-based pay system. So it would allow us to vet some of these claims before even burdening an employer with a request.
Follow up, Representative Grossell.
So, I mean, from what I'm understanding, they can get this information if there is need for an investigation. The threshold, probable cause versus what did you say your threshold is? And that's for Mr. Moller.
Mr. Moller.
Representative, the threshold is reasonable grounds in the statute.
Now, is that a lower threshold than probable cause?
Yes, it's a civil threshold.
Mr. Moller.
I apologize. Yes, Representative, it's a civil threshold, which is generally a lower threshold than probable cause, which is the criminal threshold.
Representative Grossell.
Thank you, Madam Chair. And I guess I don't know to the author, I guess, what problem are you trying to fix here? Because it would appear that they have access to what they need to investigate. Should there be need for an investigation, and to allow more access when you don't have to. It's a lower threshold that they have to meet, other than probable cause. You know, I'm not comfortable with any AG's office, no matter who's a majority. I'm not comfortable with any AG's office having more access than what they should to businesses or to private for the citizens of the state. I really don't think there is an issue here as far as trying to fix something. I guess I will ask the author, what are you trying to fix?
Representative Greenman, and then we're going to move on to other members.
Thank you, Madam Chair, and thank you, Representative Grossell. This is a fix that allows the Attorney General's office, for this specific purpose only, the same way that we allow, I think it's 18 other agencies, both state and local, to have access to this data. And what it does is it actually reduces, as Assistant Attorney General Moller said, it reduces the burden on employers of having to go directly to them. Right now, if you had access to this data that is privacy protected in the same way that it is when it exists with DEED, they would be able to clear complaints that may not have merit. Without that, they're going to go directly to the employer, which is asking for information that they could have otherwise gotten, and an additional burden. That's the problem we're trying to fix. It's more burdensome on employers, the current status, and it's also more resource intensive for our attorneys.
Right, Representative Feist.
Madam Chair,
Representative Grossell, we got to move on. I've only got 6 more minutes to committee. Representative Feist.
Just one more thing.
Representative Grossell, if I go to you, then Representative Johnson doesn't get to speak, and that's not fair to him. So I'm going to go to Representative Feist.
Thank you, Madam Chair. And I just wanted to echo Representative Greenman and also Mr. Moller's comments. This issue is crystal clear to me because my husband used to work for the AG's office. And so I understand like these civil investigative demands are really unique. And these are a power, I believe, that only the AG's office have in our state. And that is to issue these documentary requests before they've even initiated litigation. And so it's very easy for the AG's office to issue these requests. And when a company receives them, it can be very cumbersome and stressful. And so I just think that's an important point to make, is that these civil investigative demands can be sent, you know, like Representative Grossell saying, maybe we don't want the AG to have this power, but we have invested them in this power. And it can, you know, they can have a fairly low bar to issue these CIDs to companies and ask for these documents. And so this is just a really smart, elegant way to make sure that they don't have to burden those companies with these types of requests. Thanks.
Thank you, Representative Feist. Representative Johnson, and then we'll move on to the vote. Representative Johnson.
Chair Becker-Finn, Representative Greenman, I have a lot of concerns on this bill. There's 18 agencies that are gathering the information, looking at the information, see if there's anything that's wrong. If they find something that's could be, I believe we're talking about the wage theft issue here on a civil side of it. They have that information. They then turn it over to the AG's office, who does the investigation and looks into it. They have the information if they find something wrong. I'm sorry, but the only way I can see this bill is a total fishing expedition looking for things, which is not how this state goes and not the proper way to do things. Representative Greenman, one question for you on this bill with the data. Is there any audit trails in this bill to make sure that we can make sure that the information that's being shared is being shared properly and it's not being used improperly?
Representative Greenman.
Thank you, Madam Chair, and thank you, Representative Johnson. I think I will turn it over to Assistant Attorney General Moller to describe the standard operating procedure that the Attorney General uses.
Mr. Moller.
Yes, Chair. I just want to make one clarification to some of the earlier questions. This is not currently data that the Attorney General's office can receive. So this is always going to be stuff that currently we have to go to employers for. Even with reasonable grounds, the statute doesn't allow DEED to give us this information ever. So that's why the proposed change is in place. In terms of audit trails, government systems are generally conditioned on a user access policy, which is typically drafted and provided by the agency maintaining the system, which in this case would be DEED. And then there's always an auditing mechanism built in, and oftentimes that's built into the platform itself that is providing the data, where the user has to, for example, put in a reason for running the search, or it could be connected with each investigation at our office is assigned a particular docket number. So every request could be linked to a particular investigation. And that's handled by the agency with the access. And then there's always a periodic review of the activity where an agency can initiate an audit or can request audit information periodically to ensure that the access is being used for legitimate purposes and how it's intended.
All right, thank you for answering that question. I will renew my motion that House File 3015 be referred to the General Register. The clerk will take the roll.
Finn.
Aye.
Mueller.
Aye.
Scott.
No.
Feist.
Aye.
Frazier.
Aye.
Grossell.
No.
Her.
Aye.
Hollins.
Aye.
Johnson.
No.
Liebling.
Aye.
Long.
Aye.
Mortensen.
No.
Novotny.
No.
Farr.
No.
Robbins.
No.
Vang.
Aye.
Zhang.
Aye.
That is 10 ayes and 7 nays.
All right, the motion prevails. House File 3015 is referred to the General Register. And with that, members, we are adjourned.